Hey everybody, we're making some good progress through section 3. We're right in the core of it, covering some civil rights and civil liberties. So today we're going to dive into these topics. Let's get going. So learning objectives, for one, my objective is to have Mo's interference be as limited as possible. Hey Mo, goodbye Momo. All right, so we're going to look at the definitional differences between civil liberties and civil rights while looking at how they have played out through U.S. history. We're really going to go through a deep dive on, oh, that's a cell phone that just hit the ground. We're going to do a deep dive on the progression of our fight for civil rights and civil liberties within the United States throughout history by really looking at a couple key eras: abolitionist movement, Reconstruction era, civil rights movement, and the modern fight for civil rights. So we're also going to look at key legislation that impacted those time periods. Think of the Civil Rights Act of 1964 and the Voting Rights Act of 1965. We're also going to dive into segregation, both de facto and de jure segregation in the United States, and how it played out and how policies either helped or restricted the implementation of these systems. So let's get going. So definitional, let's get some concrete definitional distinctions, all Mo's being cute, between civil rights and civil liberties. So civil rights are protections from other individuals within society. So think of it as your protection from other groups or discrimination by majority representation within society. Think of this as the protections from others. We have guarantees of equal citizenship and protection from discrimination by majorities. So civil rights is your protection from majorities. And when you visualize civil rights, you think of the civil rights movement of the 1960s. You think of fights for minority rights against oppressive majorities. When we think of civil liberties, in contrast, it is important to make a clear distinction. These are constitutional protections against the government. When you are protecting your civil liberties, you are restricting the government. And in certain circumstances, when you're protecting civil rights, you may even be expanding the role and influence of the government to ensure your protection from other collectives within society. So when we look at policies that both strengthen our civil rights and civil liberties, we often see government improvements, government strengthening when it comes to civil rights, the strengthening of the state's capacity to protect individuals. While when we look at civil liberties, we're oftentimes seeing the restriction of government to ensure the protection from an unruly government in our daily lives. Now, when we also cover these terms, it's very important to bounce back and understand the mechanisms we use to push back against restrictions of these rights and liberties. And that is most often and most effective civil disobedience. These are peaceful protests in which individuals reveal unjust laws by simply disobeying them and being arrested for it, or simply getting out and protesting and disrupting daily lives to reveal detriments in public policy. So we see there are many periods of civil disobedience, and often it's acts of civil disobedience that enable our government to act and protect our civil rights and restrict itself to ensure our civil liberties are secure and protected as well. So when we look at this fight for civil rights and civil liberties, it is not one that has been won in any given moment. No piece of legislation progressed this movement to an absolute end, but we do see it's a fight that started at our foundation and continues to this very day. Of course, we know the battles that persisted in the formation of our nation, but we also understand that after that civil war we experienced in the 1860s, we came out and entered what's known as the Reconstruction era. The abolitionist movement was successful, and we abolished slavery, but now we must deal with how this state will be structured with these new freed individuals. So we see the 1868, the 14th Amendment coming alongside the 13th and 15th around those same years, representing the Reconstruction era amendments. Of course, these were not enough, as these amendments protecting our right to be citizens and vote in this nation were restrictive, only including those 21 years and older and of that were males. So we see we need the 1920s suffrage movement to reach its peak when we see the implementation of the 19th Amendment and the granting of women's full suffrage and their right to vote. This is, of course, a continued fight that we see persisting until throughout the entire time period, with a peak in the 1960s when we, for the first time in 1965, have legislation that protects both men and women's right, regardless of race or gender, to be able to vote in these United States. And we do our best to abolish Jim Crow era legislation. We also see that fight continues today. We see protections from our federal government in Supreme Court rulings like Obergefell v. Hodges, which we covered in recent lectures, in which we have the federal protection for same-sex marriage in all 50 states, which was previously not provided before the year 2015. So we see this fight for civil rights and civil liberties is not defined by any one collective or any one journey or battle, but it is an ongoing fight to protect ourselves from majority groups and protect our rights and liberties from oppressive governments when those circumstances come. So, how do we protect our civil liberties? Let's focus exclusively on our civil liberties for a brief moment. And remember, these are protections for you from your government. Think of our Bill of Rights. The government cannot restrict your freedom of speech. They cannot restrict your right to bear arms. And it is simply understood as 10 amendments restricting our federal government's capacity to interfere in our states' rights. And that's an important distinction to make, our states' rights. Up until a Supreme Court ruling in Barron v. Baltimore, the Bill of Rights and our constitutional amendments only restricted state governments. It did not restrict or protect individuals when it comes to the specific interpretation of the legal code. So Barron v. Baltimore was a Supreme Court ruling that determined that the Bill of Rights only applied to the federal government and not the states. And this ruling will persist for years to come. Then we see the 14th Amendment coming in the Reconstruction era, about 35 years later, determined that no state shall enforce a law that challenges the privileges or immunities of citizens of these United States. And we utilize the 14th Amendment Equal Protection Clause to expand the protections that the Bill of Rights provides for our civil liberties to also restrict state governments as well as our federal government. So we'll go into this at the end, the connection to the anti-federalist discussions that we had at the beginning of the semester. Remember, we got to remember that material. So we'll review that material and look at it through the scope of how we required selective incorporation because of the way in which we advocated for state protections instead of individual protections during the formation of our Constitution. So what is selective incorporation? Selective incorporation is the case-by-case process in which our Supreme Court said this Bill of Rights does not just apply to our federal government, but it also applies to state governments. The federal government cannot restrict your right to freedom of speech, and neither can the state governments. The state government has no right to restrict your freedom of speech, to restrict your right to bear arms, to restrict the liberties and civil liberties presented in our Bill of Rights. And it was a process of selective incorporation following Barron v. Baltimore that overruled that interpretation and secured that we will restrict the state and federal governments from overriding our civil liberties. When we talk about government, it's important to make these distinctions and understand it through a lens that helps us both analyze these issues critically and understand counter perspectives rationally. And when we look at advocacy on the federal side, especially when we look at legislation intended to either restrict or expand civil rights or civil liberties, we often see rationalized sentiments focusing on liberty or security. Do we want to ensure greater liberty at the risk of providing less security, or vice versa? And when we look at the relationship that we have between our state security and our liberty, it's important to ask yourself these three questions to see what you advocate for when we have security threats like, say, COVID pandemics or 9/11. And we have policy initiatives that may restrict liberties, like mask mandates or like the Patriot Act. But it's in the name of greater security. And there are moments in time in U.S. history when we have to decide what priorities will we make in this given moment, the protection of liberty or the protection of security, because all policy actions tend to prioritize one over the other. Now, how do we provide civil liberties and civil rights? I briefly addressed this earlier, but when we think about civil liberties, it's often understood as best protected through the limitations of government. That's why we see the Bill of Rights being an optimal example of this, as it is a restriction of our federal government. Thank you, selective incorporation, for also making that a restriction of our state governments as well. We also see when we look at civil rights and how we'll look at civil rights in this lecture and examine it throughout history is we see that oftentimes, because it is a protection for individuals from majority groups, it requires the expansion of state capacities and state intervention to ensure the protection of civil rights, while civil liberties have opposing practices. We think simply as the Reconstruction era amendments. We needed 3 constitutional amendments to ensure, these civil rights. We needed the Civil Rights Act, the Voting Rights Act, and much more legislation to ensure that these protections are provided for individuals among society. And at no point in the fight for civil rights do we see a diminishing of the role of the state, while in the fight for civil liberties, we quite frequently see that diminishing role. I also want to briefly cover the role of social movements in the United States, as they're front and center when it comes to any moment where we implement greater protections for our civil rights or greater restrictions of our government to ensure our civil liberties. So we see that we have, in a sense, a participatory democracy in the United States. We have the capacity to engage and influence our government's actions either through elections or through direct opportunities like ballot referendums and mass votes on specific government, which are mass votes on specific government actions. So we see this role of individuals and citizens. And oftentimes when individuals and citizens are not content with the actions of their government, they act through social movements. We see mass protests. In recent years, we've seen representation of these mass protests revolving around the role of the government, the role of the executive, even the role of these institutions when it comes to the COVID pandemic. So we see mass protests coming from both partisan sides that represent a disdain for the current direction and are representative of calls to action for our government. Now, it is important to understand that every single movement in the United States and abroad has, in every single instance, incited a counter movement. So when you may go out there, if you are interested and mobilized by one of these issues and you protest and you see opposition, do not meet them with conflict and understand that there is a rational societal dimension that is occurring in front of you. There will always be counter movements to any social movement. When we also look at social movements, it's important to understand that there will also always be those who benefit from the progress of a social movement without adequately contributing to that movement itself. Think of the civil rights era. There were some young individuals who did not go out and take part in sit-ins, who did not involve themselves in the mass protests or the walk on Montgomery. And we do see them in the end benefiting from the expansion of civil right protections within the United States. So we see there will always be individuals that do not contribute to a social movement to the extent that they benefit from it. And we will see at various points in U.S. history a focus on this free rider problem, echoing the disdain for those who just are simply benefiting off the coattails of others. But understand simply that it is a mechanism that will always be at play when it comes to social movements in the United States, and it's the extent of the free rider problem that will determine the effectiveness of a social movement, as there will always be some, but there is an extent in which it can be diminishing. We also see the importance about framing revolving around a social movement. Framing is mobilization of certain preconceived conceptions or prejudices. This can often mobilize millions before even specifying policy advocation, but by simply conveying the general sentiment of advocacy. We see framing can implement divides within policy discussions that immediately find you on one side of a partisan angle. So we see that social movements in the United States do persist. They will have counter movements, they will have free rider problems, and they all rely on engaging in expression that makes the most out of framing opportunities around certain issues and are often timeliness regarding current events. When we look at free speech in the United States, one of those constitutional amendments that we oftentimes take for granted, one of our key protections of civil liberties, our right to say whatever we want to say. But it's important to understand that this has developed over years. It required Supreme Court interpretations. It required legislation to help interpret how we will go about protecting the freedom of speech of individuals without allowing absolute activities. So Let's rewind a bit. Let's go back to 1919, in which we see Schneck versus United States, in which we saw the result of a Supreme Court ruling being that speech can be restricted if it poses a clear and present danger. This was driven by a case where there was a person handing out draft-resisting pamphlets during World War I, a war that we see general sentiments not in favor of draft resistance, and any pushback against drafting of individuals or encouraging draft resistance at the time was action that put the state in jeopardy, as it could diminish our capacities at the time to recruit military personnel. We see this has developed over time, as we do not see the restriction of individuals due to draft resistance. We even see mass pardons being provided by Jimmy Carter following the mass number of individuals who were resisting the draft in the Vietnam War. But we continue on to see the Smith Act of 1940, in which we saw the forbidding of advocating for the overthrow of the government. This is a scenario where there was blatant advocacy against the United States government, and there was a legislative act that was implemented in the year 1940 to ensure that if you were to call for violence or incite violence against the state, you are restricted by the law. Something just fell in the kitchen. We also see Brandenburg versus Ohio. This is in 1969. We're getting a lot closer to contemporary days, ruling in which we see the government cannot punish inflammatory speech if it does not incite any specific person to enact any specific act of violence. This is oftentimes what we understand as our inaction freedom of speech that persists today. That we can call for the overthrow of the government, but we cannot call for Jim to overthrow that government today. And we see this having played out in recent events over the last decade, and we've even seen some judicial interpretations within our courts covering the accountability of individuals in authority positions during moments where there may have been incited violence. We see right around the same time, 1964, New York Times versus Sullivan, landmark ruling that implemented the interpretation of libel and slander laws that we rely on to this day. By that I mean libel laws are laws that protect individuals from written defamation harming one's character, in which the author knowingly published that written defamation, and slander, it is the same thing but for spoken language when published online or in the media. So we still to this day have libel and slander protections that are merit for a lot of civil suits within the United States to this day. Now, let's start a dive through history. We're going to look at some key moments in U.S. history and key time periods. I want to start with the abolitionist movement. I think a beneficial way to examine the abolitionist movement is by examining the impact of some key actors, some that have slowly faded out in our scope of history, and it is important and essential to remember many of these individuals. So let's begin with John Brown. John Brown was an individual. He was a white male individual living in the northern Union states. He was a leading abolitionist who at one point led a raid on Harper's Ferry in Virginia. He was extremely religious, motivated by God to lead a slave rebellion for the freedom of the true men of this nation. He believed his actions would spark a mass slave rebellion. Although this did not happen, he did have some control at Harper's Ferry for a notable time period, although it did result in, at the end of this raid on Harper's Ferry, John Brown losing his life in 1859. He was, as I mentioned briefly, mobilized by God to lead a mass slave rebellion. He believed that God would have sent this message to all slaves of the South, and that once he led this raid on Harper's Ferry, there would have been a godly mission and mass rebellion. Although he was mobilized to enact an action that resulted in the eventual abolitionist movement's success, he did not see success in his raid, as many individuals of the South were not notified of this slave rebellion and did not act in that given moment. But it is also important to note that this was not the only slave rebellion that had occurred in this time period. We have a notable individual in U.S. history by the name of Nat Turner, who died at the young age of 31, leading a mass slave rebellion in which 200 enslaved individuals were eventually murdered at the end. This rebellion, once again, was not successful. What happened at this rebellion is a reveal of the capacities of those individuals in the South. And what it did is it also brought national attention towards the treatment of these slaves on these southern plantations. What also occurred at this time period was an extreme increase in oppressive behavior of those plantation owners and slave owners of the South. Oppressive leadership, oppressive rule would be revealed to the mass public in the years following. And without this slave rebellion led by Nat Turner, which was the end of his life, we would not have those eyes seeing the atrocities of the actions of those in the South. We also know an individual, Frederick Douglass. We know him as a great actor of oratory skill throughout our U.S. history, being a representative both in state and out of state, advocating for the rights of formerly enslaved individuals. He was one that was given opportunities to convey sentiments, and he did not back down or bow his head. Instead, he spoke freely and openly, and he gave a speech on the White House lawn on the 4th of July, stating directly, "What to the slave is the 4th of July? This 4th of July is yours, not mine. You may rejoice, I must mourn." End quote. Saying directly to the faces of those with power and in charge the reality of the lives that him and his fellow statesmen have lived. Without his oratory skills, we would not have the representation of the lived experiences of those in the South during the abolitionist movement. We also see another individual representing the intersection of movements. We were not just fighting a fight for the end of slavery and the freedom of individuals, but it was a fight for multiple collectives simultaneously. There was a suffragist movement. Women were advocating for the right to influence their state governments. They were advocating for greater rights within their household. And at this time, there was an intersection of these movements. There were mass movements and protests for women's suffrage that oppressed the voices of those African American women within their collective. Sojourner Truth was one of those. And there was a moment in which there was a public protest, an Ohio Women's Rights Convention in the year of 1851. There was a protest to be led down the main streets in Ohio, ending at the convention. And Sojourner Truth tried to march. And what happened as she tried to march is she was stifled by individuals, leaders within the suffragist movement, saying, "If you join this march, you will delay the progress of women's ability to obtain the right to vote, because we cannot have us representing the intersection of race and gender matters at this time." And Sojourner Truth stood strongly, stating, quote, and giving a famous speech, "Aren't I a woman?" demanding that she reside in that march and progress the rights of women, both white and African American women of the time. We see another moment, not an actor, but a moment in U.S. history that is representative of many that have fallen to the wayside in our acknowledgments of this time period, and that would be one of the many riots that resulted in hundreds of lives lost. We see in the city streets of New York City, there was an 1863 draft riots and massacre, which mass violence was led by a white mob against a black community in New York City. This is not a one-off scenario. There were cities in the South, thriving black cities of the South, that were overwhelmed by mass violence. In this New York City draft riots, we see the largest mass insurrection in U.S. history outside of the Civil War. And this is where we saw between 120 to 400 lives lost and one entire week of constant violence in the streets of New York. These actors in this moment in history represent a time where fighting was the only choice you had to be able to persist and exist in this nation. And we see these people fighting in different forms, advocating through their oratory skills, through their means of civil disobedience, or even on the most extreme senses, in the hands of John Brown and Nat Turner, needed violence, political violence, in opposition to policies of oppression. In no way does this slide advocate for political violence, but it reveals the nuanced reality of our history, that actors have taken multifaceted approaches to protecting their civil rights in this nation. Now, abolitionist movement was successful. We abolished slavery, end the Civil War. The Union has won, and we are stepping out of this Civil War. It is 1865, and we have to address some issues. We have two main goals of this Reconstruction era. We must reunify the southern states with the Northern Union and address the status of formerly enslaved populations. Just like in the Revolutionary War, there was mass debt and economic hardship predominantly impacting the southern states. We also see an era in those southern states where there was an implementation of black code legislation. This is legislation passed highly predominantly in the southern states, in which you saw extreme restrictions of civil rights for those African American individuals. Some of these include required yearly labor contracts or individuals would face arrest, basically making it to where unemployment was illegal, while also being restricted from having employment in the vast majority of industries of the South. Restricted all work outside of plantations, as an example of those work restrictions in the region, from non-white Americans unless a tax was paid. There was they allowed for any white citizen to arrest any African American for simply suspicion of a crime. This expanded the role of our policing and incarceration institution within the United States, a dimension we will explore at the end of this slide. They also banned ownership of guns for individuals of the South, and we saw an institution of sharecropping cropping up, which we replaced slavery with a pittance payment of the same activities, as sharecropping was work on plantations for non-white individuals to be paid a pittance of pay, and oftentimes paid in the crops that they harvested. We also see this at a time period which hit a peak as we saw the first impeachment in U.S. history, in Andrew Johnson's impeachment, which was led due to his his pushback against Reconstruction era legislation, as well as some misconduct relating to his cabinet and some of those members and how he advocated for their removal at certain times. Although the primary mechanisms that led to his impeachment were his pushback against Reconstruction era legislation that was supported by overwhelming majorities within the United States. This Reconstruction era would bring three key constitutional amendments to be examined right now. The first of which is the 13th Amendment, which abolished slavery and involuntary servitude. We see additionally the 14th Amendment, in which all persons born or naturalized in the United States are full citizens. That is the dimension of this 14th Amendment that applied most directly to this Reconstruction era. Although the 14th Amendment, as we remember from our judicial branch lecture, has been expanded and interpreted on in depth, especially relating to the Equal Protection Clause and the Due Process Clause to be a foundation for many Supreme Court rulings in even recent years. So 13th Amendment, abolish slavery. 14, grant citizenship, although it is quite an expansive amendment at large. And the 15th Amendment granted people the right to vote who were previously restricted due to their race, color, or previous condition of servitude. But it is important to note, gender is not included. And if you read the specific text of this amendment, it specifies all men above the age of 21. Something that will be revised through later constitutional amendments. So the 14th Amendment, let's look at these sections in detail. Although it is important to remember the main distinction and takeaway from this time period is that it implemented birthright citizenship in the United States as a constitutional protection. And if one were to abolish this birthright citizenship, it must be done via a constitutional amendment aligning with the constitutional protections of our United States government. So let's look at these sections of this 14th Amendment. See, first, the first section addresses state action, privileges and immunities. This is where we see that simple presentation of birthright citizenship and presentations of due process and equal protection clauses, which are to be predominantly relied on in later interpretations within our court system. We see Section 2 addresses the apportionment of representatives to Congress. Section 3 forbids anyone who participates in insurrection or rebellion against the United States from holding federal office, at the time heavily restricting those Confederate soldiers and advocates from taking part in the newly formed and newly solidified union government. We also see that this has been relied upon in recent years and has been examined by our court system, as we've seen many individuals who have run for office who may have participated in recent insurrections or contributed in some sense regarding, and we have had recent Supreme Court rulings that have laid foundational interpretations for these processes and strengthened the third section of our 14th Amendment. We see Section 4 addresses federal debt and repudiates debts accrued by the Confederacy. As we remember, it was a key part of the Revolutionary War, as it was a foundational point that resulted in the advocacy for the federal bank and the assumption of state debts. We see that the state debts that were accrued by the Confederacy were once again a key part of what we needed to address in the Reconstruction era. And then Section 5 expressly authorizes Congress to enforce the 14th Amendment. We often see in constitutional amendments the final section indicates who is responsible for enforcing and ensuring the effectiveness of this constitutional amendment. So let's look at that due process clause of the 14th Amendment. I think it's valuable to go in depth on these specific dimensions, although we will remember the 14th Amendment as presenting citizenship and protecting citizenship for those born in the United States. So the Due Process Clause states directly, quote, "Nor shall any state deprive any person of life, liberty, or property without due process of law." What does this mean? It says that it limits the state power, ensuring that states cannot deprive individuals without fair court procedures. Due process of law is your constitutional right to stand in front of a judge and have our court system address the charges that have been brought against you, and instead of allowing executive enforcement agencies to exclusively address your process within the United States court system. So we see within our due process clause a distinction between procedural and substantive. Procedural focuses on how the government acts. Think of it being, the government must follow specific regulations protecting individuals, while substantive due process clause focuses on what the government can or cannot do. So regardless of the fair application of customs, some liberties require extensive protections. So we see procedural due process and substantive due process founding the interpretation, especially during the Civil Rights era, in uses of the Due Process Clause of the 14th Amendment. We even see distinctions between originalist critiques of the Due Process Clause and living constitutionalist defenses of the Due Process Clause. We see that originalist critiques, they heavily critique the substantive due process, arguing that it is illegal judicial intervention, as is not directly stated in the Constitution, excluding the quote in which it says that you must be provided that due process of law. A living constitutionalist would say that the substantive due process must evolve to protect human dignity and autonomy and address developing threats in society for individuals regarding our civil rights. So let's look at the Equal Protection Clause of the 14th Amendment. It says directly, quote, "No state shall deny to any person within its jurisdiction the equal protection of the laws." This ensures that states will treat all individuals and groups equal under the law. When we look at Equal Protection Clause, it's important to understand the formal and substantive equality dimensions of it. Formal equality is that all individuals must be treated the same under the law regardless of background, while substantive equality recognizes that past structural inequalities require differential treatment to achieve fairness. Now, we see this being revisited in recent years, especially when it comes to certain activities of Ivy League institutions, as they have various admissions mechanisms in which they prioritize certain candidates to ensure certain quotas for the equal protection of opportunity within the United States. Now, we see these implementations have been pushed back in our recent court system, and we've determined that we've seen recent priorities of formal equality over maybe substantive equality. But it is an important distinction to acknowledge when you look at what it means to have equal protection within the United States. We also remember that Equal Protection Clause of the 14th Amendment was foundational in the 1896 Plessy v. Ferguson ruling, but also foundational in the same overturning of that interpretation of our Constitution by our Supreme Court, stating previously, you can follow the Equal Protection Clause if you are separate but equal, but we do see in Brown v. Board of Education, the ruling identified that separate education is inherently unequal and does not align with the Equal Protection Clause of the 14th Amendment. And now we have acknowledged the reality. We've made it out of the Reconstruction era. The southern states are reunified with the North. We have addressed the livelihood of those formerly enslaved to a degree, while we have shifted the issue into the Jim Crow era. We see the Compromise of 1877 being the end of the Reconstruction era and the beginning of the Jim Crow era, where we saw that federal troops left the southern states after the Reconstruction era goals were met. This is oftentimes pointed at as a point in which we plateaued our progress. We had federal deployments in those southern states to ensure the protection of formerly enslaved individuals and citizens of these United States, the dismantling of black codes, and the protection of our civil rights and civil liberties within our southern states. But we have hit the Compromise of 1877, and federal troops will be sent back home, and we will trust the efficacy of these southern state legislatures. We enter into an area where we have highly restrictive laws enacted to limit minority access to polls. Think of the poll taxes, grandfather clause, literacy test, primaries, can't even speak, primaries understanding clauses, and so much more. We see that if you wanted to cast your vote in the southern states, you had to pay a tax. You had to prove that you had a grandfather who had the ability to vote prior to the Reconstruction era. That means you couldn't have been black in the United States and have voted prior, so you would not have been able to, even if you had the right to vote, prove that you had a grandfather who casted a ballot. So you would not be able to vote in many southern states utilizing the grandfather clause. We had literacy tests. At the time, many were restricted from obtaining an education, and then we were requiring the expression of that education to be able to cast a ballot. In many instances in the United States, in those southern states during the Jim Crow era, we even see the white population would not have had the capacity to complete these literacy tests effectively, although they were not tasked to complete these literacy tests to be able to cast their ballot, as it was exclusively designated to only certain individuals. We have, and that is similar to those understanding clauses that were implemented in the South as well. In addition, we also see white primaries. Remember in the past that political parties had the capacity and responsibility over running their primary processes. And they at the time utilized this power and responsibility to make it to where you had to be white to vote in a political primary, indicating the title of white primary right there. When we look at the notable figures of the South, we know those great civil rights advocates like Martin Luther King and Malcolm X fighting for the equality of individuals in every United States city. We also see individuals standing on the opposite side of the spectrum. Strom Thurmond and George Wallace. Strom Thurmond at the forefront of this time period, operating primarily in the 1940s and 50s, representing those Southern Dixiecrat Democrats, the Democratic Party of the South, who were pro-segregationist, advocating highly for the restriction of the civil rights of individuals within those Southern states. We see this movement was later taken over by the name of George Wallace, who ran for president in the 1968 election, representing the persisting sentiment of those Dixiecrat Democrats previously led by Strom Thurmond, who we might know and remember as being the representative who has presented the longest filibuster in U.S. history at 24 hours and 18 minutes as he filibustered the 1958 Civil Rights Act, resulting in the slowed delay of the civil rights protections for those within the United States. We do see that we did have the Civil Rights Act enacted about 6 years later, as we see the Civil Rights Act of 1964 and the Voting Rights Act of 1965 were implemented as law. This began and ended the Supreme Court ruling on civil and voting rights legislation, ended with the Supreme Court ruling in Brown v. Board of Education that supported this legislation. That enabled this legislation. And we see that these two pieces of legislation are worth specific examinations in the following slides, as they were pivotal in finally giving the federal government the means to ensure protections of civil rights, while also providing the federal government with the responsibility of ensuring that equal protections are provided to all individuals regardless of gender, race, and other circumstances. So, what were these restrictions? I briefly covered them, but I think it's important to go through them in detail. We have the white primaries. Only white citizens could vote in primary elections, enabled by the reality that primaries are governed and ran by political parties themselves, their internal decision-making processes. We see the grandfather clause. This restricted voting to those who could prove they had an ancestor that voted prior to 1867. What happened prior to 1867? We had high restrictions on voting rights, and this is a joke of a policy if you thought it protected the expansion of those newly protected voters in the United States. We also see poll taxes, requirement of fees to be paid in order to be able to vote, and literacy tests requiring people to read, recite, and interpret complicated texts that even the white populations of the South were not capable of doing, but were not tasked to do so. Beyond these clear and observable mechanisms restricting access to the polls, we saw social barriers, including mass violence of peers that would happen if one were to attempt to cast a ballot, resulting in many southern states having as little as 5 or less % of the black population casting ballots in the elections in which they were first granted the right to do so. And now we fast forward to 1920. The 19th Amendment, where we finally gave women full suffrage. This amendment says, quote, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex," focusing exclusively on the suffrage of women of the United States. This required further legislation to provide all women accessibility to the polls, as there were nuanced restrictions for those being able to cast their ballot in many states. Many Western states provided women the right to vote as early as the 1860s, for example, as Wyoming expanded the right to vote for these individuals. So we see that this was not a one piece of legislation that expanded this right to all, as there were many states leading the forefront of this civil right. So we also know that there were other nations globally that were protecting the right for women to vote at the same time. When we look, it may surprise you some of the states that protected this right for women prior to the United States. We see that Azerbaijan, Sweden, Russia, Estonia, Latvia, Lithuania, Poland, Austria, Germany, New Zealand, Australia, Finland, Norway, Denmark are all, and not the exclusive number of nations that provided the right to vote for women prior to the United States implementation of the 19th Amendment in 1920. And in summary, segregation persisted through the entirety of the Jim Crow era. Jim Crow laws built upon black codes of the South, enforcing segregation in many instances in our public and private lives. Plessy v. Ferguson established that this segregation will be constitutionally legitimate as of 1896, only to be dismantled by the later Supreme Court ruling in Brown v. Board of Education that established that separate is inherently not equal. But this was, of course, going to require legislation. In 1958, we made an attempt to implement the Civil Rights Act, but it was successfully filibustered by Strom Thurmond, one of the many instances in which the filibuster was utilized to halt the progressive civil rights legislation of the time. We also see it was later expanded in 1964 via the Civil Rights Act and the later Voting Rights Act, in which we built the federal government's capacities to protect individuals' voting rights, while also ensuring that we have legislation that includes men and women of all genders and races to be protected in their right to vote. And I always like to include the reality that when we look at the grand scheme of U.S. history, we oftentimes disassociate through the struggles of the past generations. We inherit the progress and diminish the challenges that they may have faced. And it oftentimes is important to remind us that the United States has protected segregation legally and constitutionally for 70 years. And it has only been 60 years since we banned it. So it is important to understand the relevance we have in time to the segregation and policies that impacted the United States. And we will explore in the next slides 2 distinct types of segregation that helps us understand why it is important to understand how recently we've dismantled this practice. So there is de jure segregation. This is in contrast to de facto segregation, but de jure segregation is what we can visualize here. It's what we visualize when we think of the darkest parts of U.S. history, the Jim Crow era, those black codes being in effect, in which we had segregation established through laws that enforced this division within society. The United States prior to 1964 represents a society in which de jure segregation was in full effect. The separation of groups of people according to government enacted laws was tangible and visible. It wasn't just, and it is important to also understand when it comes to de jure segregation as a concrete as a term, it does not just include race, but also class, gender, age, and much more. We still see forms of de jure segregation that persist today, predominantly around the topic of gender in especially institutions like the military, for one. So we see de jure segregation is the legally implemented segregation of groups. De facto segregation, as you can see represented and visualized in that ChatGPT created picture, is when segregation is still in force, but not because the government is enacting policies that protect segregation and the division of society, but instead because we have social tendencies to divide along these previously implemented lines. Many parts of the United States persisted with de facto segregation for decades and decades following the dismantling of de jure segregation. It is nearly impossible to immediately abolish de jure segregation without entering a period of de facto segregation. Let's remove ourselves from the topic and examine briefly, just verbally, the issue of South Africa post-apartheid. We still, to this very day, South Africa had de jure segregation up until the 1990s and officially abolishing it for what is now still de facto segregation. As you see, some neighborhoods divided by only one street represent over 95% one race, while the other side of that street represents 95% of the opposing race, with significantly different class capacities and mobilization among them. In the United States, this reality also persists. There are many communities that still have the long-lasting impact of one dominating race over the other. There are no legislations that are enforcing this, and there may even be no practices by, say, those selling homes in these regions that are restricted to one class over the other. But the downstream impacts of institutional inequalities and lack of class mobility has resulted in mass collectives still being harmed from the persisting effects of de jure segregation and living in a society in which de facto segregation exists on certain levels, in which majorities of a population may be represented by one race, gender, etc., while we have those opposing populations in maybe the opposite side of the track with far more class mobility and resources being provided. We still see resource allocation representing on some level collectives that are to this day de facto segregated. So I always love this image right here because it depicts a time period, again, that is far closer than many of us like to make it out to be. 1964, the Civil Rights Act banned discrimination on the basis of race, gender, color, religion, or national origins at polls, public accommodations like schools, hotels, and restaurants, enabling the federal government to sue in order to desegregate these schools. Now, why did we have to build our federal government's capacity to do such? Because we previously had Brown v. Board of Education determine that segregation is not legal within our education systems in particular. But we do see a time period that occurred in the county I was born, in which the public schools, and I want to repeat, in the county I was born. If my father was born in the county I was born, he would not have obtained public education from the year of 5 to 10. Because in 1964, we have had the abolition of providing individuals public school education because of the policies calling for the desegregation of schools. Individuals in the county I grew up in were more willing to not educate their children than to educate their children in the same room as individuals of another race, revealing the extent to which this issue was internalized and the extent to which we required the expansion of our federal government's capacities to protect the civil rights of many individuals in the state that I was even born in, Virginia, and many south of it. So we know the Civil Rights Act expanded the federal government's capacity to bring civil suits to state institutions that are restricting individuals from access. But we also see the Voting Rights Act of 1965. We see depicted up there with Lyndon B. Johnson and Martin Luther King Jr. shaking hands at the signing of this legislation. This was an act prohibiting discriminatory voting practices such as literacy tests and established federal oversight in areas with high levels of voter suppression. We are abolishing the means and the tools utilized to restrict minorities from reaching these polls, and we will ensure that the right to vote is one that will be protected for all. We see prior to the Voting Rights Act of 1965, only 5% of the eligible African American voting population was registered, not casting their ballot, but registered to vote in 1954. This same community skyrocketed to over 60% of the population being registered to vote following the Voting Rights Act of 1965, revealing that they needed the government's expanded support to be able to provide their ballot. And now we enter in the modern era, where we see that we often overlook this continued fight for civil rights and civil liberties. But it does persist to this very day, with many individuals being progressed or restricted with gender equality, disability rights, LGBTQ rights, and so much more, including examination of those rights of those who are incarcerated in this United States. So we look at the gradual history of expanding civil rights and civil liberties, and we understand that it is not over, and it continues to this day. We see Title IX prohibiting sex discrimination in education and workplace environments, only implemented in the 1970s. Disability rights requiring notable legislation through the Rehabilitation Act of 1973 and the 1990s Disability Act, providing these individuals access to public accommodations. Also, LGBTQ plus rights, not previously federally protected until the year 2015, where I was nearly graduated from high school. It was the time where we first had these true federal protections. We see that there are constant pieces of legislation dismantling or emphasizing our civil rights and our civil liberties. And we as citizens have the responsibility to have oversight over the actions of our government in the modern era as well as in the past. So let's look at the civil rights and the modern prison system. What are the stats that tell us how we are addressing incarceration in the United States? The United States has the most citizens incarcerated globally. This is 2.1 million, and this is data from the year 2019. The United States has 5% of the total global population, yet when we look at those incarcerated, we hold 25% of the world's prison population. The prison and jail population in the United States had peaked in the year 2008 and has been on a gradual decline ever since, and that peak reached 2.3 million individuals. When we look at incarceration globally, it is very important to understand the distinction between incarceration rates and number of total individuals incarcerated. Yes, we have the greatest number of citizens in our prison system. No, we do not have the greatest incarceration rate globally. We have the 6th greatest incarceration rate globally. Those who lead include El Salvador, with the highest rate of incarceration as 1,086 of every 100,000 individuals, citizens of their state are incarcerated in any given moment. In the United States, we are 6th in this list at 531 individuals, U.S. citizens, per every 100,000 U.S. citizens that we have incarcerated. We also see inequalities represented within our prison industrial complex. We see that we have about 32% of the U.S. population consisting of Black or Hispanic citizens. When we look at our prison industrial complex, that number balloons to 52% of the incarcerated population coming from these communities. We also see that when we look at the downstream impacts of having a mass prison industrial complex, we have high number of dollars spent. The U.S. government spends about $6 billion each year housing roughly 2.3 million inmates. Even with that number declining, we see that persisting to this day. We also see that we acknowledge that this is not a result of one party policy. This is a result of numerous policies that restricted that provided more guidance in the incarceration process. We look at some periods in which we called for the war on drugs from the 1980s to the three-strike mandatory laws that come in the 1990s, stemming from both political parties, resulting in this being an issue of mutual responsibility and accountability within the United States. And a little reminder in Obergefell v. Hodges. Not only was this a Supreme Court ruling implemented in just the year 2015, but it is one that came down with a 5-4 decision. It was a landmark decision that just barely made it into being passed, that resulted in our equal rights protections being solidified on the federal level when it comes to equal marriage. Now, to wrap this lecture up, I want to have a brief discussion that revisits that term we covered earlier, selective incorporation, one you might want to remember for a quiz. So, I want to make a connection to the beginning of this course, as we see the downstream impacts of original intentions in advocacy for policy initiatives. So let's rewind. We remember that the Anti-Federalists and the Federalists were the two collectives divided over whether we should ratify our Constitution. The Federalists said the Articles of Confederation were so weak we need to strengthen our federal government. The Anti-Federalists were very fearful of a strong federal government. And one of the compromises made for the Anti-Federalists was we will implement a Bill of Rights, which is a protection of our civil liberties, in which we will not allow the federal government to override the civil liberties of the states you represent. That is a very important distinction because it required later Supreme Court rulings to address it. The Bill of Rights only restricted the federal government in protection for the state government. This is distinctly different than having the Bill of Rights protect the government in protection for individuals. It protected state governments from the federal government, as that was the main concern at the time, as these were not citizens of the state necessarily as much as they were representatives of the state legislatures. So we see the Bill of Rights was implemented to protect the state governments from the federal government, and it directly restricted those federal governments. Now we fast forward a bit, and we have an 1800s Supreme Court ruling in Barron v. Baltimore. What did Barron v. Baltimore say? Barron v. Baltimore said, yes, this is exactly how we should interpret it. The Bill of Rights restricts our federal government and protects our state governments, and one cannot use the Bill of Rights to restrict our state governments in order to protect individual liberties. Well, we see in a process called selective incorporation, here's that term, in which we started on a case-by-case basis, relied on our Supreme Court to interpret that every one of our Bill of Rights not only applies to restricting our federal government, but it also restricts our state governments. The state government cannot, just as much as the federal government cannot, impede our right to freedom of speech, impede our right to bear arms, and overrule our judicial protections and due process clauses. So we see the connection is now clear. Selective incorporation was required because at the onset of our nation, the Anti-Federalists were advocating for protections for state governments instead of individuals, and we see that expanding to be a protection for individuals through later interpretations within our Supreme Court, relying on the due process clause of the 14th Amendment, revealing that we are constantly editing our systems of government, and we have compromises that are made effectively and optimally, and it is beneficial, but we will have downstream impacts and harms from these compromises and policy initiatives. And it takes a constant eye on these efforts, a constant acknowledgement that we must ensure that civil rights are protected for all individuals, and we expand our government's capability of protecting those civil rights while we restrict our government's capabilities of restricting our civil liberties. I also have one quick slide that I hope that you watch on your own. I have posted this video on Eagle Online, and it is it's like a 2-3 minute video, and it's just a presentation of what civil liberties are from the perspective of a Canadian political scientist. So our neighbors north, I think it's beneficial to see how these concepts apply so similarly in many states, and we can use this as a resource to understand how civil liberties are presented and implemented in the United States. Here are those what do we learn slides. Here are those key points that you should make sure that you can confidently answer at the end of this lecture. And make sure your answers are correct. So good job, everybody, in getting through the first half of this course. I hope you had a good spring break. I hope you'll listen to this lecture, and I hope you're gradually getting those comments on your midterms back. I'm still working through them. Got a very busy week, so it'll be ebb and flow between how many I can get back to you, but I will get them back as soon as possible. If you are concerned, or if you are somebody who spends a long time in the writing process and you want to get your comments back as soon as possible, email me. Light that fire. I'll get you those comments back right away, so you can begin the writing process. But I also know that many of you are not going to pick up this paper until the end of the semester. So I will get that back to you right away. If you want to light a fire, email me, and I'll make sure I get that back to you even faster. Thank you, guys. Make sure you go through Eagle Online to ensure that you are meeting all your needs with the course, with assessments, quizzes, and all readings. Thank you. Have a good rest of your day.